today. Eric Stafford with the Kansas Chamber.
Thank you, Mr. Chairman and members of the committee. My name is Eric Stafford, Vice President of Government Affairs for the Kansas Chamber. I have a bill introduction dealing with pyramid promotional schemes. This is being introduced on behalf of our Direct Sellers Association members who are out of state and unable to travel due to COVID, and it is RS number 0209. 0209.
Okay, without objection, we'll go ahead and enter that. Thank you.
Thank you.
Any other bill introductions? Any online? Okay, then we'll go ahead and move on. We're going to open the hearing on HB 2066, and we'll get an explanation of the bill from Charles Reimer, the revisor. Charles, are you there?
Yes, thank you, Chairman. I had trouble with my microphone earlier today. Can you hear me?
Yes.
All right, awesome. So 2066, the committee will recall, is a bill that expands a current statute that just applies to military service members with respect to facilitating their ability to obtain a license or a certificate or registration in Kansas. It expands it to all applicants from other states who have credentials from other states or who have work experience in another state and wish to work in Kansas, or who have a private certificate from a private credentialing agency, and they wish to work in Kansas. So that's just a quick, brief overview of the bill, and stand for questions.
Are there any questions for the revisor? Okay, we'll open discussion on HB 2066, Representative Croft.
Thank you, Mr. Chairman. I make a motion to pass House Bill 2066 favorably.
Seconded by Representative Hoffman. And we'll open discussion. Representative Croft.
Thank you, Mr. Chairman. I do have an amendment. It's a balloon amendment, as you directed, to capture all the input provided during the hearing and after. And I've also added a portion today that I believe will address some of the concerns of the medical society. So,
Charles, are you prepared to explain the amendment, or do you want Representative Croft to do that?
Representative Croft can do so. Would you like me to put the amendment up on my screen, or do the committee members have it before them via the email distribution?
If you would put it up on your screen, and if you have not emailed the amendment to Cindy, would you please do so that she can circulate it?
Yes, she has circulated it.
This would be the first of the two amendments, right?
This would be the second.
Second amendment. Okay, great. Representative Croft, yes, Charles, if you could put that up on the screen, it'd be great, and then we'll have Representative Croft run through the amendment.
Okay.
Thank you. Representative Croft.
okay. Thank you, Mr. Chair. And Mr. Chair, if at the end, if I fail to cover something, then hopefully we'll be able to let the revisor do cleanup for me. As we go through this, right up front, what I want to talk about is I was thinking yesterday just how humbling it is to get to work on these kind of things for people who are frustrated and having a difficult time moving to Kansas. Again, the intent of this is about helping people who want to move to our state and practice their profession to fulfill their dreams and provide for their families. I saw it time and time again in the military where the government put up barriers and folks weren't able to provide for their families in the way that they were trained to do so. With that, I'm not going to cover all this. I'll cover some of this at the end. What I wanted to cover through is that You know, we changed the language of this bill. It was asked for me up front. Why did we change that? Well, we looked at the Department of Defense was asked to look at the two standards, and they were directed to conduct this study through their National Defense Authorization Act. And in doing that, they found that the first set of language was not actually achieving the intent, but that a similar scope of practice would help accomplish that intent. So I've talked to every single person that has asked to come to my office, and I've met with everyone, and I've received numerous emails. And to be fair, I did not include everything in the amendment that has been requested, but I will go through each of them. Right here on the first page, for instance, there was a discussion about what are we going to do as we keep changing the uniform service or the military armed services. So as a result, we changed that language right there to reflect a situation where if we change and no longer have a space force, or we add another force that we can't think of, then this language doesn't have to be changed again. So it's a universal language use. And then on the second one, we use that in linking to, excuse me, the military spouse definition. So with that covers that first page. Then there's some more minor changes, and what I'm going to do is probably the best is just to go through it, how they're effective. So on section M, which is the telemed piece, this was by far the biggest issue that we had and that was discussed. And I absolutely believe this is important legislation. There have been various recommendations for changes from the Board of Healing Arts, as well as from the insurance industry and several others. However, and they've been incorporated, however, at the request and promise of the chairwoman of the Health and Human Services Committee, we were going to remove section M and place that language in the telemedicine bill. She's committed to ensuring that language is going to be included. So that's what we did there, that's why that section is removed. There was a question about fingerprints. I did speak with the KBI. I just wanted to confirm that we had the same thing that we had last year. KBI's goal and their standard right now is 2 weeks to process fingerprints. In most cases, if you come from another state and have a license, your fingerprints are already on file, which actually speeds up the process for KBI. In the study, in the Department of Defense study, they also found that it takes about 30 days for people to process the paperwork. So if you remember our definition of a completed application includes getting all the paperwork in from various organizations, which has been determined to take about 30 days. That combined with the minimum standard of 15, you're at 45 days minimum, more than enough time to get the fingerprints processed. So I just confirmed it. I wanted to make sure we were good there. Some of the changes you've seen on the engineers have requested some technical changes and adjustments to clarify the relief valve, and that's what you see there. It was only included in one section, and we missed it in the other, so we cleaned all that up per the engineers, and I want to thank them for that catch. The surveyors came to me and asked about adding back in welfare. And we spent a good part of this weekend trying to define welfare, went through many different sources. And welfare, as we looked at it, was just too imprecise of a term. However, we do believe in reviewing the language, and I believe it's in section N, that they are covered with what they wanted to do with their pressure relief valve. So I think we've accomplished that task for them as well. As far as the architects, and I know many people have heard from the architects, and I appreciate their interest in this. They brought to me several concerns. One of their concerns was lawsuits. One is not protecting the public, and the other is being exempt. I asked for the specifics of the lawsuit, and to this point, I've received nothing from them about a lawsuit, any lawsuits that have been done. So I went out and checked with Arizona, and some people may be fans of Arizona, some may not, but they do have an experience factor now. They have 2,600 licenses they've issued under this program, and they've received 0 lawsuits as effect of being denied for a license, and they have had several denied. They have had one lawsuit, and that was because there was a resident who had been in the state for several years, had a license still existing from another state, and wanted to apply under this program. They went through the process, and they are accepted into the program. So that's the only one that I could find out there. There was others mentioned about California. Again, nothing provided, and I couldn't find anything. As far as for not protecting the public safety, I think we've included that with the pressure relief valve as we've done, and especially with the changes that were mentioned. And then the final request was to be excluded. and nobody under the jurisdiction of the legislature is exempt. Well, we've talked about lawyers, but they're not under our purview, so therefore no one is being exempt. The Board of Technical Professionals requested a technical change, which I included in the amendment. They also requested to be exempt, or at least be part of Section S, and I did not support that. I did take this request seriously, and in the end, the argument just wasn't compelling in what they talked about. The argument was that they agreed with the bill last year, and they agreed right at the end, but the point is that 99%, 98% of their licenses is already through the national process. They're probably one of the least affected in this system, and if this does not overwrite compacts, it does not overwrite any other things, personally, and from what I've read in all the studies, they would much rather have all the compacts. This becomes a backup bill to the compacts. So if we go down that route, then these things are less likely. These are not as important as the others. From a Kansas Medical Society testified as a neutral conferee in the bill that was drafted. And while we certainly haven't made many of the changes, we haven't made any changes to have them opposed, but after multiple conversations, what I think the real concern is for the medical society is that a professional, let's say a nurse practitioner with a broad scope of practice in another state, comes to Kansas, gets a license, and somehow maintains that broad scope of practice. That's not what this bill does. And I have confirmed that with the revisor. That is not the case. The nurse practitioner, while being eligible for a nurse practitioner's license, would have to abide by the scope of practice statutes in Kansas. AMS suggested some other changes to accomplish what they were afraid might happen above. First, they requested being exempting nursing, pharmacy, optometry, and dentistry. And if they were not exempt, at least include them in subsection S. And second, they asked that we strike the word similar before the word scope of practice. That would ultimately, we don't believe that that's needed to occur, and we've already included the Board of Healing Arts and some of that in the subsections, but the similar enables that flexibility for the board to consider other things of work experience. Ultimately came to the conclusion that their suggested changes would have serious negative consequences to the military families and others moving to Kansas. The Board of Healing Arts, the Board of Pharmacy, the Board of Dentistry, and the Board of Nursing, who the Medical Society requested exceptions, none of these boards, none of the associations associated with them have asked to be exempt. I specifically had a meeting with several pharmacists and others, and they said they had no issue and they are comfortable with the bill. With that being said, I spoke with Charles, our revisor, about the solution that might be more targeted without negative consequences. And so this is what we did agree to, is a blanket statement, and I think it's right up there right now on your board, that says nothing in this act amends Kansas scope of practice statutes, and that any applicant approved in this act shall have their scope of practice governed by the Kansas statutes. So I think I tried to accomplish their intent with that. And again, there was a discussion about litigation, same argument as before, still received nothing. Americans for Prosperity recommended including a one-year work requirement to licensed individuals to strengthen the work experience. I believe that's up there. No, he's finding it now. Right there on the top of the screen, what is that, page 3? That was something in there to make sure, as was mentioned before, you don't want to create a duplicate system. That was the only section where it mandated work experience, and so we added that in there. That was a great catch, and we really appreciate them having us do that. They also requested that Section M remain in this bill, and unfortunately, we're unable to support their request. The Institute for Justice recommended removal of the relief valve. In other states, they've seen that valve to be used as a barrier, to which the intent of this bill is to remove barriers to employment and get people back to work. And I feel in the interest of finding common ground for both sides of this aisle, of our aisle, and all involved, to leave in the pressure relief valves, and we'll see if in the future it becomes a barrier, and then we'll take it out. But right now, I think it's important to keep that in there for the safety, as was mentioned by the architects and many others. I think I forgot, no, I did mention already the services. I know this bill is not exactly the same, and I've had a conversation with many of you about that. But the point is that we're here, it's about the intent and serving the intent. I do know that last time we did have a comment about the education board, or licensing board, and they haven't come forward again. They didn't come forward last year until the very end. They didn't come forward, did try to engage, didn't hear anything back. So at this time, I do expect something in the future. I just haven't heard anything right now. Mr. Chairman, I believe I think I've covered all the changes in the bill.
So the Education Licensure Board, we did have conversations, or you did have conversations with them about this bill last year, and you did everything you could to appease them as much as you could, from what I can remember. Is that correct?
Yes, Mr. Chairman, that is true. That is correct.
Okay. Maybe that's why they didn't come forward this year.
Let's hope so. And Mr. Chairman, I do stand for questions.
Okay, are there, Charles, did he do an adequate job of explaining the amendment, or do you have anything to add?
Chairman, I would just add, if you look at the screen on the bottom of page 2, there's just an addition of this state to clarify that we're talking about the licensing body of the state there. That's really a clarification. And he talked about page 3. Those are just corrections. We're adding, and he may have addressed this, just on page 3, we're adding some language, just again, more in the nature of clarification, I think, and he may have addressed this. This is an important change here. If you look at this page, is a page that deals with the temporary permit process. And if you look at H, we have language shall issue. If you look at H line 10, that applies to military spouses or non-resident military service members. So the language is not discretionary there with respect to issuing a temporary permit. In the bill as drafted, the language with respect to other applicants was discretionary. The licensing body had discretion whether or not to issue a temporary permit. That's been changed to shall. The final paragraph, subsection here, pertained to individuals with work experience or a private certification. And here again, the language in the bill as drafted was shall. So adding shall makes all those subsections consistent. And then is to sort of mirror the language with respect that's already in the bill with respect to individuals with work experience or a private credential. We have added the same language to each of the other 2 provisions, both dealing with military service members and other applicants, that the board, and again, the language is shall there, so the board shall issue a temporary permit. And then we've added, unless the licensing body finds, based on specific grounds, that issuing a temporary permit would jeopardize the health and safety of the public. And that is added to both of those subsections, the H dealing with military service members and military spouses, and I dealing with other applicants.
So Charles, for further clarification on that extra sentence you put in there, that would be specific grounds as far as the individual that's applying, not grounds that, well, we don't think it's a good idea to, or that it's safe to issue temporary permits, correct?
No, not temporary permits in general, correct, Chairman. The idea there is that the licensing body shall issue the temporary permit unless the licensing body finds that they're, issuing that permit would jeopardize the health and safety of the public.
Representative Croft.
Yes, Mr. Chairman, and that's the pressure relief valve that we were talking about. And those were the changes that you see on that screen. The top one there was brought by the, okay, I'll remember the board here in a second.
Engineering?
It was that board. And then the other parts there were what was brought by the engineers themselves. And the shall was just a consistency thing that they identified that we failed to catch this time that we did catch last time. So but that pressure relief valve is there if you find that it's unsafe or endangers the health, then you have that ability as the board and the right to not issue the license, which is, I think, some of the concerns that the architects were concerned about when they came to me. So, thank you, Mr. Chairman.
Are there any questions for the bringer of the amendment? Or clarification questions for Charles? Online? Okay. Seeing none. Oh. Representative Curtis.
Thank you, Mr. Chairman. Just to clarify on the pressure relief valve. So by changing that language, then the only way that a temporary license is not granted is if it's found to be in the safety or in the life or safety of people. Is that correct? Is that what pretty much that language change does?
Charles Reimer.
Representative, so the way page 5 is set up, the situation is where an applicant has applied and the licensing body has determined that the applicant's credentials does not authorize a similar scope of practice as the credentials issued by the licensing body of Kansas. So in that situation, the idea is that a temporary permit should be issued to provide the applicant the opportunity to complete Kansas requirements. And the language, so that's the context of those changes. Does that help with your question?
Yeah, that does. Thank you. That kind of clarifies it. Thank you. Appreciate it.
Any further questions? Seeing none, Representative, you may close on your amendment.
Sorry.
Representative Croft.
Yes, sir. Thank you, Mr. Chairman. I was trying to make sure I wanted to talk now or later about where we're going, but I will. I think, Mr. Chairman, at the bottom line, I just want everybody to know that this was a lot of hard work that went into this thing, and that there is a tremendously diverse group that supports the amendments and what we've tried to do. AFP, IJ, Kansas Chamber, Wichita Chamber, the Women's Foundation, the Governor's Administration, as long as we took out Section M, has expressed support for the bill. And I hope you will agree with me on this amendment and where we're trying to go in supporting our families in our state that want to come here and provide for their families. So with that, I move, Mr. Chairman.
For the record, Representative Hoffman has seconded the amendment, the motion. All in favor of the amendment, say aye. All against, say no. The ayes have it. The motion passes. Back on the bill, any further discussion on the bill? Representative Hsu.
Thank you, Mr. Chair. I also have an amendment. I can explain it real quick if you want.
You go ahead. This is the other amendment that was emailed out. Is that right, Representative? Okay. That's correct.
And I really respect the previous representative for all of his work. I think he and I just kind of landed on different sides on whether or not we found the Board of Technical Professions, their argument, and then it seemed to make sense to me. Their concerns about different standards for out-of-state versus in-state sounded almost exactly like the Board of Healing Arts. So it's a pretty simple amendment. It just essentially adds the Board of Technical Professions in with the Board of Healing Arts. For my personal perspective, I'm going through a remodel right now, and I don't want the architect to get mad at me and throw a column in the middle of my new kitchen. So that's why I'm bringing this forward.
I might be able to help you with that. Okay, Charles, can you put that amendment up if you have it?
Yes, Chairman, I will do so. I will do so right now.
Okay, for the record, Representative Clayton has seconded the motion. Charles, do you have anything to add about the amendment? Go ahead.
No, I think that pretty well covers it. If I can find it again here, it just as the additional board. And yeah, there's the language. And just adds the additional board to that paragraph whereby the bill would apply to them, but the scope of practice standard would not, and they would use the substantially equivalent standard.
Okay, is there any discussion on the amendment? Representative Highland.
Thank you, Mr. Chairman. Is the carrier of the bill and the previous amendment okay with this amendment?
Representative Croft.
Thank you, Mr. Chairman. I am not, actually. I respect the position that we're coming in from, but this is a negotiated bill that has gone through a lot, and we've placed ourselves in this position where we are today. And I think this would open up and have us to go back and potentially renegotiate the entire thing. So no, I'm not supporting.
Representative Clayton.
I have a question for the carrier of the bill. So since this is a negotiated bill and a negotiated amendment, can you tell us who does not want the Board of Technical Professions included?
Well, personally, I think Section S was a section I didn't want in the first place. But we're here right now where we're at. I can't tell you all the other ones right now, but I have a list in the office. Maybe I didn't understand your question. Could you please ask me again?
I want to know who opposes this amendment. I know that that you personally do, but I think for the edification of the committee, it might be not wise to know which organizations don't want this. I know it's a negotiated bill, but if a lot of these negotiations did not take place before the committee, then I think that we need to know this before we take next steps, please.
Yeah. I think that's a question that we ought to direct at the carrier of the amendment. Who would be against or for that?
Representative, I think the argument here is that it was a negotiated bill and every profession would like to be considered into the same category. And when we start going down after telling everybody that this is kind of how we're going to do it, and you start allowing one in and one out, then it doesn't ever stop, and everybody wants to be considered the same way, is the way I understood it. Could be wrong.
Okay. I think just largely my concerns lie in this regard that I think a lot of the work that we do does take place behind the scenes, but just from a transparency standpoint, knowing, these negotiated bills that take place outside of committee, they do kind of bring cause for concern here. So I'm having trouble getting my head around why these groups should not be included, whereas others can. So since I was not in the room, and nor were a lot of the other people in this room, nor were our listeners at home, I just would like to just have a little bit more information if possible.
Representative Hsu, do you have any further information?
Not particular, not who opposes this. I know the architects came to me, and I have apparently 1 million of them in my district, and they're the ones obviously in support of this.
Okay, so in regards to the amendment, as I was saying earlier, there have been several other professions that have wanted this same consideration, and when you start going down that road and allowing one in and one out, then the bill begins to unfold and the intent disappears. And in my opinion, as far as the architects and engineers go, when you take a national test that is the same test that every other architect takes, it lessens the argument of being able to move from one state to another. I mean, I get it if the standards are different and tests are taken in each state, and some more states are more stringent than others, That's one thing, but that is not the case in this case. And this was put together as a way to bring Kansans into Kansas and be able to work, and that was a barrier to entry before. We also have a workforce development issue in Kansas, and there are firms that need to hire engineers and architects, and there aren't enough of them. And so that's the reason that we have set up the bill, or Representative Cross set up the bill the way he did. Representative Williams.
Thank you, Mr. Chair. And this is a question for the carrier and the amendment. So do you happen to know offhand how many licensures will go for those that are under the technical profession state board? So for example, architect or engineers, how many of those do they issue annually?
I do not.
And do they perhaps share with you how many would be impacted by this legislation?
They did not.
So I don't want to refer this question to Representative Croft, but it's probably a small number of individuals that come in with this type of licensure that fit all the qualifications to take advantage of this bill. And the only other thing I'd like to mention is that in terms of backdoor dealings, I think that's that's an inaccurate way to describe this. And the reason I say that is that we had open hearings. Testimony could be provided by any entity, individual, organization. They could have made their requests known at that time, their viewpoints made at that time, and that is all open to the public. So, thank you.
Representative Curtis.
Thank you, Mr. Chairman. I'm not an architect, I'm not an engineer, so I'm sure you're all very relieved at that. But in my conversation with the representatives from the trade, what resonated with me is that there are, evidently Kansas has a very high standard. All of our licensure are NABB, not sure what that stands for, but they are all accredited through that. There are 17 states that they have experience in lieu of the NABB accreditation. There are 14 states that do not require it at all. So that leaves 31 states that do, that have the same standards as Kansas. So I'm just wondering if, number one, we don't want to lower our standards. We want everybody to come up to our standards. Is there a way to recognize those that have that NABB? It seems like they would be the ones that would be natural for moving through the pipeline very quickly and getting their licensure. I don't know if that was considered or not. I know we're working the bill today, but that would be, I would think, one solution to look at. And so anyway, and then another question that is a little bit off of this topic, we did get a fiscal note. So just the practicality as we move forward with this policy change in how that works. I see that it's effective upon publication in statute. So I don't want us to lose sight that this policy measure does come with a cost. So, and that's all I have. Thank you, Mr. Chairman.
Representative Probst.
Thank you, Mr. Chair. To make sure I get this microphone right, I've been told it requires a little bit of engineering to position it just the right way. This would be probably for the carrier of the bill. Just from my knowledge, to make sure I understand, the original bill didn't create any exceptions for anyone. Is that right? I mean, specifically Board of Healing Arts, they weren't in the original. They weren't exempted in the original version of the bill.
You're talking about 2 years ago or last year?
No, this one. They were still.
They were always. This has been, that part did not change.
So they have a do they have a carve out that allows them to exercise some discretion, the Board of Healing Arts, or are they subject to this fully?
They're fully subject to it, just as it states now.
Any further discussion on the shoe amendment? Representative Miller.
Thank you, Mr. Chairman. I'm not following that answer. The answer that this fully applies to them because it says they shall not be exempt except that, which says it's, the word except tells me they're not fully covered like everyone else.
Maybe I just misunderstood the question. You asked if they were carved out of this bill, and they're not carved out. They are affected by this bill. That's what I was answering.
But then, and that part I followed, but then somebody, either you or him, used the word fully covered, but it says except. That they are not exempt except, and then there is a carve out where if the Board of Healing Arts determines the applicant's qualifications are not substantially equivalent, then they can deny it.
Thank you, sir. That's the same thing that all the others have as well. If they find somebody doesn't meet the standard in this thing, then they cannot issue the license.
Except that I thought that was the whole purpose of Representative Shu's current amendment, is to make the same language apply to the technical professions as the Board of Healing Arts. And it would only, the license can be not denied only when the qualifications are not substantially equivalent to those established by the board. One case, Board of Healing Arts, the other case, Board of Technical Professions. And I don't understand why we treat doctors and dentists and their qualifications different than we would engineers and architects. And contrary to Representative Shu, I have the same number, I think, of doctors and dentists as architects and engineers in my district, which is pretty close to 0.
Any further comments? Representative Probst.
First, I want to thank Representative Miller for picking up my slack. That's exactly the point I was trying to get at. Why we said we wanted this to be comprehensive and didn't want to start carving anybody out, but we clearly created an except for clause dealing with medical professionals, but we're not willing to do that for technical professionals. And I'm wondering why we made that distinction.
I believe that is the case. That is how the bill is written, and I think it was written, purposely for that, especially last year as well. Representative Croft, do you care to comment on that, or?
Yes, it helps to turn on the mic, sir. Other than the fact as we started through this whole process, we started moving everybody, we moved everybody into this. We wanted to make sure that we had done all the right things, looking at all the different states and everything that was going on, and we chose through the negotiation process that we would make this for them for now, with making sure we didn't make a mistake on our doctors. And then we could move towards them to the other statutes and get rid of S in the future, is the intent.
So, and that's the reason that we're having discussion on the bill, and we have an opportunity to make an amendment and discussion on the amendment. Representative Highland.
Thank you, Mr. Chairman. I'm confused. If you're on page 6, line 41 begins subparagraph N, and it specifically states on the next page that if the licensing body determines that the granting the application may endanger the health and safety of the public. So they already have that caveat in there that they can deny the licensing. And then why are we having this also added in? It doesn't make sense to me. It sounds a little redundant.
I believe that when Representative Croft went through his amendment, and that's the purpose of adding those sections. I mean, it doesn't bring it quite to the level as the medical profession, but they certainly gave them something in a way out in the case of safety. Any further discussion on the Shu amendment? Any online? Seeing none, Representative, you may close.
Mr. Chair. I just want to touch on, yes, there are national licensing requirements here, and what that in effect means, from what I've learned, is that they already have reciprocity. It's already pretty expedited when people move into this state. So the net effect, in the end, because the whole point of this bill, I believe, is to expedite licenses, the net effect essentially would be just a difference in standards between out-of-state and in-state. Which again was the same argument made for the Board of Healing Arts. So just with that statement made, I close.
You've heard the amendment, seconded by Representative Clayton. All in favor, say aye.
Aye.
All against, say no. Noes appear to have it. Noes do have it. The motion fails. We are back on the bill. Any further discussion on the bill? Representative Ralph.
Thank you, Mr. Chair. First off, my apologies to the committee that I'm late to the party in regard to this particular proposed piece of legislation, but I did want to make the committee aware that I've had conversations recently with the carrier of this legislation in regard to one concern that I have. I wanted to make the committee aware of that. It's not my intention to vote against this today, but I intend to have additional conversations in that regard. On page 2, the sub-capital A, there's some language that was changed from the last time we considered this a year ago that described a situation where the applicant has a certification equivalent to those established by the licensing body, and the language has now been changed to the applicant has certification that authorizes a similar scope of practice. My concern is whether the intent of the legislature in making that change of language would be clear somewhere down the road as to what is different about those two particular phrases. I'm not sure that I see what that distinction would be, but we've had some good conversations, although, albeit they were short because of my not being available, if you will, and I appreciate the carrier of the bill being able to come down on short notice and have those conversations, and didn't intend to have some more, but I did want the committee to be aware that that's a concern I've got in relation to those two pieces of language, and intend to have some additional conversations following today. Thank you, Mr. Chair.
Representative Miller.
Thank you, Mr. Chairman. I apologize if this was addressed in the hearing. I think I understand the basic intent behind the bill, but my understanding of the intent is what raises this question on line 32, page 1. Why are we extending this to former members of the military?
Representative, I think we're not only extending it to the former members of the military, but any individual moving into the state. Representative Croft, you want to comment on that?
Thank you, Mr. Chairman. Actually, if the revisor could just talk about that for just 1 second first to help me out. Because I want to see that part of this may have been changed or not changed, and I can't remember what it says right there, and I don't have it on my screen. I apologize.
Yes. So, yes, on page 1, line 32, the addition of or former member with an honorable discharge, and you are correct, Chairman, that the bill not only applies to military service members, but it applies to all applicants, as you indicated. So there is a provision that adds military service members and defines them to be former members. Now, one difference with respect to military service members, including former members with an honorable discharge, and other applicants, is that the bill is set up so that military service members generally receive more favorable treatment. They're supposed to get their credentials faster. So there is a little bit of a difference through the bill in how military service members and other applicants are treated, but the bill applies to all applicants who have credentials or work experience or a private certification in another state and wish to work in Kansas.
Is that good?
Actually, your explanation confused me more because my question now would be if this is anyone moving into the state, why do we bother to define military service? And he kind of hinted around at that we treat them the same, but we don't treat them the same. But I got lost in the explanation, and that's just me. I get lost a lot.
So do I, and I tend to be one of the leaders in getting people lost, so I apologize for that. However, the reason that we're discussing the military members in the first place is because that's where the statute began. We had a statute that allowed military members and their spouses, when they get transferred here, to be able to practice their practice from their other state. And when we expanded this to any person moving into the state that has a valid license, we also wanted to make sure that we addressed the former military part of it, because we didn't have that was not in statute before, so that if a former military with an honorable discharge moved here, they would be able to practice. And the difference, as Charles, and I had forgotten we discussed this, but as he just stated, the military members do get first priority, so when they get here, they can get up and running quicker. And just by adding former military to that section as a definition, it allows them to also have priority over other non-service individuals.
Okay, then I go back to my earlier question, why? Why are we giving, I understand the military aspect, and that we were talking about families that don't have much choice about their move, but why are we giving preference to former military members over the other people? Just because we are?
Kind of people we are.
Okay. Thank you.
Representative Clayton.
Thank you, Mr. Chair. And this is just a question for the maker of the bill. I think that we do want to reach a compromise here. I'm wondering how accepting you would be of a potential motion to table, only so that you would have the opportunity to discuss this with those of us that have heartburn, rather than going through and reworking the bill on the floor, just giving us a chance to, perhaps meet with you and sit down and be part of this negotiation and discussion. There are some organizations, for instance, that I really support that are in favor of this. And so just putting that out there to see if you would be amenable to tabling and maybe reworking this later on this week, fitting it in pending discussion. So I don't want to get aggressive or anything, just, trying to be a peacemaker here. Thank you.
Representative, if you would like to make a motion like that, feel free. However, in order to expedite things, we've got to address this bill today. If not, we have unemployment in front of us, and that starts later this week. And I would imagine that's going to take at least a week and a half or 2 weeks, and it will be a long ways down the road before we get this back up on the table.
Even if I asked really nicely?
You can ask however you'd like. We'll have to take a vote on it.
Well, if the maker of the bill would be amenable to that, then I would make a motion to table. But if not, then it's not worth getting into a huge fight. So this is just to see if you would be helpful in that regard and making that effort on my part.
Representative Croft, would you be able to make yourself available for any questions for the minority party to clear up any heartburn they have before we get to this on the floor of the House?
Thank you, Mr. Chairman. First off, I'm always available, and I've made myself available for the last 3 weeks in doing all this process. But before I go to that, could I just address one thing real quick? Reference the comment made on veterans. On line L, which is page 6, and it's actually line 4, I should say, section L. licensing body may grant licensure, registration, certification, or temporary permit to any person who meets the requirement under this section but was separated from the military. So that already veterans were included. The reason we did that in the definition was to clarify and make sure everybody understood that veterans were included. I apologize for not commenting on that earlier. I couldn't find the section and I just found it. And that is existing law today. So veterans are already included. We were just clarifying. Does that help you with that, Mr. Chairman?
Representative Miller?
Yes.
Okay, Representative Croft?
Thank you. And from that perspective, I would, as you said, Mr. Chairman, knowing that we're under this time crunch, I would much rather go ahead and continue the dialogue, move the bill forward, and then have the dialogue. I don't mind having the discussion on the floor and changing on the floor if necessary, but I would like to continue to move the process forward if that would be okay, Mr. Chairman.
All right, thank you for answering my question, and we'll go ahead and continue, I suppose, Mr. Chair.
Great. Any further discussion? Any online? Seeing none, Representative Hoffman.
Thank you, Mr. Chairman. I don't know if this is the right time, but we did pull a whole section out of the bill with our balloon amendment. I'm wondering if, much like what we did last year, we create a substitute amendment or a substitute bill. Might be a good idea just simply to clean up the whole bill and make it a little less confusing when it goes to the floor.
Representative Croft, on your motion, would you like to make a substitute motion as amended? A substitute bill?
Yes, Mr. Chairman.
Representative Hoffman, can you help us with the language on that?
Yeah, it would just be, I move that that we create a substitute bill for, substitute for House Bill 2066, favorable
as amended?
Passage. No, not as amended, because it's a new bill.
Okay. Representative Croft.
You want me to say that?
Okay, so moved.
Thank you. What he said.
Representative Hoffman seconds the motion.
Yes, I guess it is.
Okay, so committee, you've heard the motion. All in favor of the motion, say aye.
Aye.
All against, say no.
No.
The ayes appear to have it. The ayes do have it. Motion passes. Okay, committee, I don't have anything else for today. Tomorrow we have 2 bills on the agenda. If you look at those before you come, they should be a little bit less controversial. Thanks. We're adjourned.